Refusal to close is more common than we'd like to think. Generally, if a buyer refuses to close because they couldn't come up with the money or for some other reason, the seller will be entitled to the buyer's deposit. The buyer forfeits the deposit. The seller then has to share that deposit with his listing agent. Now, the seller can sue for other remedies, but usually the seller is happy to get the buyer's deposit. He's still got the property. He moves on, sells it to someone else. On the other hand, if the seller refuses to close, then the buyer is deprived of the home that they, were emotionally invested in. So the buyer has a couple of different options. The buyer can institute suit for specific performance, which is basically asking the court to compel the conveyance of the property to the buyer. The buyer might also be entitled to some money damages in that situation. If the buyer is just fed up, he can just sue for money damages. An interesting wrinkle here is if the seller sells the property to a third party while he's under contract to you, the buyer can not only sue the seller, he can sue that third party for what we call tortious interference with a valuable relationship.